The essential element of an obligation are active subject, passive subject, prestation, and juridical tie. Active subject is the creditor or the obligee. He is the person who has the right to demand performance of the obligation. Passive subject, however, is the debtor or the obligor. He is the person who has the duty to perform the obligation. He is also the person from whom the obligation is demandable. The prestation is the subject of the obligation. It is the conduct to be observed by the obligor in the performance of the obligation, which may consist in the act of giving, doing, or not doing. Juridical tie is the reason why an obligation exists. It is the tie that binds the parties to an obligation. It is also called legal tie or vinculum juris. Examples. Number 1. D is required to pay the BIR his income tax for the year 2005 on or before April 15, 2006. Here, the active subject is the BIR, the passive subject is D, or the taxpayer, the prestation is to give money to the BIR, and juridical tie is the law, or the National Internal Revenue Code. Number 2. X agreed to repair the house of Y, and Y paid 20,000. They agreed that X will start the repair of the house of Y on June 30, 2006. On the maturity date, Y is the subject, X is the passive subject, the prestation is to do the repair of the house, and the juridical tie is the contract of services. Sources of obligation. The sources or juridical ties of a civil obligation are law, contract, quasi-contract, delict, and quasi-delict. Law is a reasonable rule of action, just and obligatory, promulgated by the competent authorities for common observance and benefit. Obligations derived from law are not presumed, and only those obligations expressly determined by law are demandable, such as the obligation to pay taxes to the government, to renew the registration of cars, to observe traffic rules and regulation, and to secure a license before operating the business. The second source of obligation is contract. It is the meeting of the minds between two persons whereby one binds himself with respect to the other to give something or to render some service. Obligations arising from contract have a force of law between the contracting parties and should be complied with in good faith. The contract must bind both contracting parties. Its validity and compliance cannot be left to the will of one of them. Hence, if D obtained a loan of 10,000 pesos to C payable on June 15, 2006 plus 10% interest, then D must pay 11,000 on June 15, 2006. The next source of obligation is quasi-contract. It is a juridical relation which gives rise to the payment of indemnity for a certain lawful, voluntary, and unilateral act in order to prevent unjust enrichment. Here, there is no meeting of mind between the parties, but even if the act done by another is not authorized, he who is benefited must pay to prevent unjust enrichment. Sense of gratitude is the base of quasi-contract, and its purpose is to prevent unjust enrichment at the expense of another. The expense of quasi-contract are negotiorum gestio and solutio indebiti. Negotiorum gestio is the voluntary management of the abandoned property or business of another without the knowledge and consent of the latter. The person who manages the property and business of another without authority is called officious manager. Its requisites are: number 1, the property or business must be abandoned. Number 2, there is no meeting of minds between the parties. And number 3, the act of the officious manager must be lawful, voluntary, and unilateral. Solutio indebiti, however, is the obligation to return what has been received by mistake when there is no right to the thing received. For example, X found an abandoned house which is already dilapidated. He caused the repair of the said house and he resided therein. Several months later, the owner of the house arrived. Of course, the owner can take the house from X, but the owner must reimburse the amount spent by X for its repair, although he did not authorize X to do it. The source of the owner's obligation to pay X is negotiorum gestio. M bought 7 bottles of soft drinks from a store worth 70 pesos and he paid 100 peso bill. As a change, he was given an amount of 40 pesos. Under solution indemnity, M has the obligation to return 10 pesos to the store owner because he has no right to that amount. M's obligation to return 10 pesos is based on solution indemnity. Now, the last source of obligation is delict. Generally, in delicts or acts or some are omissions punished by law, the guilty party is not only criminally but also civilly liable, because the commission of a crime causes not only moral evil against society but also material damage to the offended party. The civil liability arising from crime may consist of restitution or reparation and indemnification of consequential damages. X carried out the taxi of Y. X was arrested and found guilty of the offense charged. X will not only be sentenced to suffer the penalty of imprisonment, but he shall also be required to return the taxi to Y or pay its value. If it can no longer be returned, he must also pay the amount of damages or lost income suffered by Y. The next is quasi-delict. Quasi-delict means that whoever will cause damage or injury to another due to his fault or negligence must pay for the damage done. The damage or injury done is not intentional but due to negligence, and there should be no pre-existing contractual relation between them. A truck driver who injured a pedestrian due to his negligence must pay the expenses incurred for the hospitalization of the victim and other damages resulting from injury. Obligations to give. Obligation to give. Real obligation. An obligation to give may consist in giving of determinate or indeterminate thing. Determinate or specific thing is one which is particularly designated and physically segregated from all other of the same class. A thing which still belongs to the class or genus is an indeterminate or generic thing. A 2-year-old dog is an indeterminate thing, while the dog of X named Blackie is a determinate thing. The creditor's right to demand for the delivery of a thing, personal right, begins only from the time of maturity, but ownership over the thing, real right, is acquired only after the thing has been delivered, because ownership is transferred only by delivery. If what is to be delivered by the debtor is a determinate thing, he must take care of the thing before its delivery, because if it will be lost due to his fault or negligence, he shall be liable for damages to the creditor. When the standard of care to be exercised by the debtor has not been stipulated by the parties, or if the law does not provide how the debtor should take care of the specific thing to be delivered, he must exercise ordinary care or the proper diligence of a good father of the family, while the same is still in his possession. An obligation to give a determinate thing also includes delivery of its accessions and accessories, even though they may not have been mentioned, but the fruits of the thing which may arise before the date of delivery belong to the debtor. P bought the only car. This is an example. P bought the only car of S on May 1, 2006, and the purchase price had been paid. They agreed that S will deliver the car to B on July 1, 2006. S leased the car to X from June 1 to 30, 2006, and S was paid the amount of 10,000 pesos by the lessee. On July 1, 2006, the right of B to demand for the delivery of the car begins, and S must deliver to B his car together with all the accessions and accessories, such as the air conditioning unit, the car stereo, and the tools kept at the back compartment of the car. However, the income of 10,000 earned by S from June 30 belongs to him. If the obligation of the debtor is to give an indeterminate or generic thing, but he failed to refused to deliver it on the maturity date, despite of the creditor's demand, the creditor may secure another thing of the same kind and quality for another source, but the debtor shall be liable for the amount paid by the creditor plus damages. In the above example, if the obligation of S is to deliver a Toyota car model 2000 on July 1, 2006 in consideration of the amount of 200,000 paid by B, but S failed to deliver it upon demand, B may buy another car for the same kind for another source, and he can hold S liable for 200,000 plus damages. If the thing to be delivered is indeterminate thing or generic, whose quality and circumstance has not been stated, the creditor cannot demand a thing of superior quality, nor the debtor deliver a thing inferior quality. The purpose of the obligation and other circumstances shall be taken into consideration to determine determine the thing intended by the parties. S ordered 1 cavan of rice from B to be given as a gift to the compadre who will celebrate his golden wedding anniversary, and he paid 1,500. Although the quality of the rice bought has not been stated, S cannot be delivered A rice, or B demand for a malagkit rice variety. The purpose for which will be used and the amount paid shall be considered to determine the quality of the rice to be delivered by S. Obligation to do. Positive personal obligation. In an obligation to do, the debtor must do it properly, in accordance with the agreement, otherwise he shall be liable for damages. As stated earlier, the debtor cannot be compelled, even by court action, to perform a personal obligation because it is against a provision or constitution prohibiting involuntary servitude. The remedy of the creditor in the case of debtor refused to do has been agreed upon, is to have it performed by another and hold the debtor liable for damages. In an obligation to do, the debtor must perform his obligation properly and in accordance with this agreement with the creditor. The law provides that if a person obliged to do something fails to do it, the same shall be executed at his cost. If the debtor will perform the obligation not in accordance with the agreement, the creditor can have it done according to the agreement at the debtor's expense. Likewise, it is provided that what has been poorly done shall be undone at the debtor's expense. Obligation not to do. Negative obligation. When the obligation consists in not doing and the obligor does what has been forbidden